Yeah, it is exactly five. Let's wait for 5 more minutes because so that let more participants do join, and then we start the meeting. Please bear with
Okay,
me. Please.
okay, sir.
I welcome everybody in the meeting. 5 minutes have already passed, and we thought of waiting for people for the 5 minutes. We can start the meeting right now, and let me share my PPT with you. And it is the same of that of yesterday. This is small introduction of mine. Moving fast. Yeah, we have a discussion paper dated 15/4, 2026 on CIIRP, CIRP, liquidation, voluntary liquidation, PPIRP, grievance, and inspection. We divided it into two parts, mainly for the reason that 10, the discussion papers are there. We have, I myself covered yesterday CIIRP. Liquidation will be covered by Mr. Anil Goyal today. Voluntary liquidation will be covered by Mr. Anil Goyal ji today. PG I have already covered yesterday. PPIRP regulation will be covered by Mr. Anil Goyal ji today. CIRP regulations will be covered by Anil Goyal ji today. Grievance and complaints already was covered by Mamta ji yesterday. Inspection and investigation was also covered by Mamta ji yesterday. Amendment to information utilities was also covered by Mamta ji yesterday. And just for the sake of repetition, all forms shall be prescribed by circulars rather than by amendments in the regulation, except for CIRP forms which has been prescribed. This is common for all the discussion papers. This is a YouTube channel. If you miss our attendance today or any of your friends miss there, then we do share the YouTube link also. Please, do join there. Small IPA contribution. We had last meeting on 6th of March and yesterday also as part one. Before yesterday, it was 87th meeting, and we have so much memberships. And R is a 7.5-year-old association, and many associations, one of the surviving associations since inception, we are there. This is a disclaimer from all our speakers, including Mr. Anil Golji, who will be there. Uh, okay, now let me see. Anil sir, आपने ज्वाइन कर लिया? Because this session has to be taken by Anil Goelji. So let me stop sharing of my this thing. एक minute, I just call him. Okay, I just spoken to Anil ji. He's at Calcutta, and something some time get extended because of he's at airport. So he will say he will join in 4 5 minutes. Till then, we can have a talk with each other, or let me. यस, मैं हर मीटिंग के अंदर यही अपील करता हूँ कि सब लोग अपना खोल दें, वीडियो खोल दें। बिकॉज उससे ये लगता है कि हमारा ये वेबिनार नहीं सेमिनार है। सर प्रसाद सर, गुड आफ्टरनून सर। मिस्टर एम एल कबीर, मिस्टर मुकेश, मिस्टर दीपक।
नमस्ते
नमस्कार
जी।
नमस्कार गुड आफ्टरनून।
नमस्कार सर। नमस्कार।
गुड
नमस्कार
इवनिंग
मनोज जी।
अनिल जी, वो थोड़ा सा 1 2 4 मिनट में ज्वाइन कर रहे हैं। तो तब
हाँ, श्योर।
तक हम लोगों ने सोचा कि हम आपस में ही मिलके बातचीत कर लेते हैं। तो अब ये बताइए, क्या कहते हैं, कितने रिपीटेड लोग हैं जिन्होंने कल भी ज्वाइन करा था और आज भी ज्वाइन कर रहे हैं?
आई
आई
ज्वाइन
आई
yesterday
एम
सर।
टेल अस। यस यस। दीपक जी, आप अपना जरा वीडियो थोड़ा सा ठीक करें। आईपी दीपक कुमार। यस, मिस्टर संजय कुमार झा। वेलकम मिस्टर संजय जी। मुकेश जी, आप भी अपना वीडियो ऑन करें प्लीज। वेलकम। हाँ जी मिस्टर प्रसाद, वुड यू लाइक टू से समथिंग?
No, yesterday class was very interesting. In fact, the interaction was quite informative. You and Beena madam have done excellent job. That is what I want to say.
एक्चुअली वो क्या नाम, हमारी जो मैडम है, तो वो थोड़ी सी कैलकाटा एनसीएलटी में फंसी हुई, कहते जैसे ही मैं फ्री होती हूँ तो आई शैल जॉइन देयर। और
Hmm.
तो इस करके थोड़ा सा डिले हो रहा है। बट इन एनी केस आई डू वन थिंग इन दैट केस, लेट मी स्टार्ट द मीटिंग। नो
Yeah.
प्रॉब्लम, वी आई कैन टेक अप दोज मैटर्स आल्सो।
Yes. Yes.
हमारे, तो मैं जो सीआरपी से रिलेटेड जो है वो मैं स्टार्ट कर देता हूँ। सो दैट जैसे ही फिर ये आएंगे, क्या नाम, अनिल गोल जी आएंगे, तो देन ही कैन टेक इट फ्रॉम मी। तो जो अमेंडमेंट्स आई हैं सीआरपी रेगुलेशन के अंदर, आई एम जस्ट शेयरिंग दैट विद यू।
Hmm.
समथिंग रॉन्ग इज देयर बिकॉज वेर आई एम ट्राइंग टू एक मिनट, चंदन, एक मिनट चंदन। When I'm opening up the particular file, I'm not able to open it up. It is showing something, some technical. ये देखना, ये फाइल क्यों नहीं खुल रही?
नाम ज़्यादा बड़ा होगा।
क्या करो? Just wait. Some technical issues coming out to be there. I'm not able to open up my file. I'm reducing its name. Then I think I will maybe be able to open it up. नाम कम करो। नहीं नहीं, कम नाम कम नहीं हुआ। Just wait for a while.
दोबारा डाउनलोड करना पड़ेगा।
I have to download this file again from the IBBI site. Hence, it will take a few seconds. Just wait, because I'm not. I opened it up earlier, but right now I'm not open it up. कौन सी है ये थी CIRP रेगुलेशन. ये से पहले तो डाउनलोड कर लेना. Yes. I think my file will be visible to all.
Yes, sir. Yes, sir.
Yeah,
We can see it. Yeah.
I'm just directly interacting with the IBBI side. So, discussion paper on amendments in CRP regulation 2016 and pursuits of the IBC code and like that करके. Changes which they have brought are information to be furnished by the operational creditor under section 9(3) subsection E, information to be furnished by the corporate applicant under section 10, manner of withdrawal under section 12A, manner of collating claims received from the creditors by the IRP, handling or possession under section 19.
This meeting is being recorded.
Yeah, deemed appointment of RP on decision of COC and its communication to IP, CD, board and adjudicating authority. Manner and conditions of the transfer of an asset of a personal or corporate guarantor. This is all. Now let me, this you can see there. Now let me, they asked for the public minutes on 28th of April, so and so. Let me, take into consideration information to be, furnished by the OC under section 9, subsection 3, subsection E and background. They have simply changed the word from prescribed to what we call subscribed. Prescribed to specified. What earlier position was that under section 9, every OC need to submit some documents as a proof of his credit. And earlier, what was prescribed, that was the mandatory required to be there. But whenever there was an adjudication and all this in there, we remember that many NCLT benches are insisting that just to prove the genuineness of the sale and debt and all this thing there, they do insist for some GSTR returns also. They insist for the confirmation of the account, balance sheets also, whereby outstanding balance of was shown and like this is there. Now, IBB has taken a part. Because when it was, the earlier prescribed was there, the statutory only the things which are prescribed in the code was required to be shown there. No, it has gone to what is specified, and in the case of specification, IBBI has got the power to specify the things which need to be required therein. I just, I have not prepared PPT on it because Mr. Anil Goyalji is taking on this thing. So now, through the Insolvency and Bankruptcy Code Amendment 2026, the above clause has been amended to substitute the word such other information as may be prescribed with any other information. The effect of this substitution is to empower the IBBI to specify through regulations any additional information that may be required to be furnished by the OC while filing an application under section 9. Earlier, this power was with the central government. What was happening was that the central government through code they were prescribing, but through rules they were prescribing that if in case of a particular firm, what need to be put it there. When we have an application for under section 7, 9 or 10, whatever is there, what need to be put in that particular form at the time of filing of the application. Now, that power has been changed, diluted and shifted to the IBBI. IBBI shall prescribe that in the case of right now we are looking into section 9 application, what matters will be specified, and they have issued a discussion paper on what things will be specified therein. Let's move forward. Proposed amendment. This amendment is in regulation 2B of CIRP regulation. The following new regulation shall be substituted, namely, an OC shall furnish the following information along with an application under section 1 of section 9, namely, copies of the relevant extracts of the GSTR 1 and form GSTR 3B, filed under the provisions of this relevant laws relating to the goods and services, and copy of the e-way bill wherever it is applicable, provided that provisions of this regulation shall not apply to those OCs who don't require registration and to those goods and services which are not covered under any law relating to the goods and services. Details of any partial information received from the corporate debtor in respect of the OC and the date of such payment, details of assignment or transfer of the operational debt, if any, along with the supporting document. And these are all things there. What my observation in this case is, and I would like that my co-friends do supplement me also there, that at present, no doubt, GST is covering approximately whole of the economy. But in the case of technically we call alcohol for human consumption, and the second is petrol and other related the things also where GST is not applicable. Number one. Number two, this GST is applicable from 1st July, I think 2017. Before that, only VAT was applicable. And what I feel is that I shall put this matter for the discussion also, that in the discussion paper they should be suggested that wherever GST is not applicable, let VAT related similar returns be filed, or something like that should be there, because that will fulfill the behind whatever the mandate IBBI is having in that way. The purpose is to verify the authenticity of the sales and all those things there. And when GST is not applicable in the case of liquor and this thing companies there, I feel that we can suggest to the IBBI to instead of these GST returns prescribed in that particular act may be filed. I just put it down. What is the opinion of others? Let me ask others. What do you feel, that should this be done or should not be done? Yes, please come forward. सर आप अनम्यूट कर लीजिए अपने आप को, मिस्टर प्रसाद.
Now, according to you, what is the advantage of doing so?
सर मेरे हिसाब से एडवांटेज इसका करने का सिर्फ यही है कि ये जो चीज़ें हैं, आप जब बेंच के में होते थे तो आप ये जेन्युइननेस ऑफ सेल को वेरीफाई करने के लिए देखते थे. उससे सेल से ही डेट क्रिएट होता था, और जब सेल से ही डेट क्रिएट होता था तो ये अब जिन चीज़ों में जीएसटी एप्लीकेबल ही नहीं है, तो उनमें अगर हम वैट की रिटर्न प्रिस्क्राइब कर दें तो उसमें या जो 1 जुलाई 2017 से पहले का टाइम था, तो उसमें अगर हम वैट की रिटर्न प्रिस्क्राइब कर दें तो दैट विल सप्लीमेंट व्हाट इंटेंशन इज ऑफ नो गिविंग जीएसटीआर 3B and e-way bill and all this thing there.
Whatever is applicable, that will be followed. No, we need not have to supplement it with anything, according to me.
Mr. Prasad, I just explained you everything. That the purpose of showing this sales was to verify the authenticity of sales transaction, because sales transactions at present is being authenticated in two ways. One is under GST and another is under VAT. They have missed the VAT. Your sales transaction which can be verified through VAT, they have missed that. So this is most, in my opinion, they have missed that, or they have, because VAT is still applicable. I given you two examples: alcohol for in simple language, liquor, and in petrol. Still, your VAT is applicable. And just to supplement for those category of industries, if that will be there, it's okay. If not there, even then it's okay. We go with the consensus.
No, according to me, you should seek a clarification.
Yes.
Yes. VAT has a place in this or not?
No, I'm sure about that. I'm a practicing chartered accountant. I'm sure about that. GST has not replaced VAT for those two things.
Correct, but that is what, let it be like a clarification rather than suggestion to add.
Okay. ठीक है sir. Anyone else? Any suggestion from any other side? Okay, now let's move to another parts on it. Consensus emerging out to be that clarification be sought rather than giving your in the discussion paper your opinion that they should be added. Rest are all, I think, normal things there. Okay, now let's topic 2, information to be furnished by the corporate applicant under section 10. First of all, sir, I just asked you that why benches are so conservative in accepting Section 10 application. Just share your experience with us, sir.
See, Section 10, the moment the corporator comes to know the proceedings are going to be initiated against him under the other provisions of law, prior to somebody initiating, he is seeking, and our experience is that he is seeking protection under Section 10.
Yes, sir. Yes, sir.
So it is a kind of using the law to the advantage.
Okay, sir. Okay.
That's only the adjudicating authority goes little slow in Section 10 applications. Nothing more than that.
नथिंग मोर देन एक्चुअली व्हाट मैं सर की बात को ही सप्लीमेंट करता हूँ। तो जो मैंने देखा है, हम लोग जब सेक्शन 10 की एप्लीकेशन फाइल करते हैं, जनरली वो एप्लीकेशन वहाँ होती है जहाँ पे थोड़ी सी जेन्युइननेस की कमी होती है। किसी क्रेडिटर को कॉर्पोरेट डेटर उठा के सामने खड़ा कर देता है और बिहाइंड द सीन या तो जीएसटी की या वैट की या इनकम टैक्स की, यानी कि जिसको हम एक सिंपल सी लैंग्वेज में कहते हैं स्टैट्यूटरी ड्यूज, उन चीज़ों से ओवरराइड करने के लिए जब उसको लगता है कि मैंने कि जैसे मैंने देखा था, जैसे एक दो एग्जांपल मैं आप सब लोगों के साथ शेयर करता हूँ कि एक कॉर्पोरेट डेटर था, उसने जो जीएसटी के अंदर एक एंट्री टाइप का बिजनेस करना शुरू कर दिया। ईडी ने उसके ऊपर रेड कर दी, बड़ी ह्यूज सी डिमांड उसके अगेंस्ट निकल गई। तो उसको उसके कंसल्टेंट ने कहा, भैया तेरे को जीएसटी में रिलीफ तो मिलेगा नहीं, तो आप किसी इंसॉल्वेंसी प्रोफेशनल कंसल्टेंट के पास जाओ, वो आपको कर देगा। द मोमेंट वी फाइल्ड आवर एप्लीकेशन एंड चांस की बात है कि सामने जो बेंच में थे वो भी सीए थे, टेक्निकल मेंबर सीए थे, तो ही इमीडिएटली कुड स्मेल इट कि ये
That's true. I did not say it so openly because
I'm sorry, Manoj ji.
You have
there were two difficulties. There were two difficulties. Let me share with everyone that I am at Kolkata and this Prime Minister would be visiting. So the total timeline got disturbed. So I had to come to the airport lounge to take this meeting. So I'm sorry for the delay, and because of this traffic, because of the PM Modi's visit to Kolkata, it was happened. Manoj, thank you very much, and I apologize for my delayed participation. Please continue, and you actually let me know what subject I have to speak. I would be speaking without the PPT, and I would be just taking clue from what you start any topic on the liquidation or CIRP. Both subjects are in fact ready with me. After the amendments and after the regulations, proposed regulations. Manoj, I would request you to take the lead and I would only add whatever you would say in any of CIRP and the liquidation subject. Yes, Manoj.
ओके सर, ओके। वैसे सर ये मैं अपने को प्रोफेसर्स को बता दूं, हमारे अनिल गोयल जी भी ना किसी धुरंधर से कम नहीं है। देखो ये कलकत्ता के तो पीएम सर के पीछे पीछे वो भी इनके साथ आ गए। और तो कल सर मैं थोड़ा सा ना, आई वाज सिंपली वेटिंग फॉर यू टू जॉइन इट। कल हम लोगों ने जब मीटिंग करी थी, इट वाज अ वेरी इंटरेस्टिंग मीटिंग, और लास्ट के अंदर सब लोगों की थोड़ी सी ग्रज कॉमन सी आ रही थी, जो थोड़ा सा टॉपिक से हटके है कि दो चीज़ों पे आ रही थी कि हमारी आईपीएस की लाइफ बहुत ज़्यादा खराब है, इन टोटलिटी ऑफ ऑल दी सर्कमस्टांसेस।
लाइफ नहीं है, इमेज थोड़ा खराब है।
हाँ, इमेज भी खराब है, और सर
ऑपरेशंस आईपी का लाइफ तो अच्छा है, ओनली आईपी का इमेज थोड़ा खराब है मार्केट में। वो हम कैसे अपलिफ्ट करें,
इमेज खराब है, और दूसरा ऑपरेशंस करने के अंदर भी काफ़ी सारी दिक्कतें आती हैं, और इन दिक्कतों को कोई सीओसी या कोई अथॉरिटीज़ रियलाइज नहीं करती। तो हमारे को काफ़ी ज़्यादा थोड़ी सी मेहनत करके प्रोसेस को चलाना पड़ता है। तो सर जैसे आज मैं अपने जितने भी हमारे यहाँ आईपी ब्रदर्स हैं, तो मैं सबको ये बताना चाहूँगा कि देखिए ये जो प्रॉब्लम्स है ना, ये सब आईपीएस के साथ हैं, इंक्लूडिंग विद मिस्टर अनिल गोयल आल्सो, इंक्लूडिंग विद मी आल्सो। लेकिन होता ही है कि जैसे हमारे अनिल गोयल जी है ना, तो जस्ट रेप्लिकेट द थिंग्स, कि जैसे भी एक धुरंधर मूवी आए थे, तो ही हैज बीन डूइंग एवरीथिंग वेरी वेरी सक्सेसफुली, एंड विदाउट पॉइंटिंग आउट एनी बेंड ऑन हिम,
कि मेरे को प्रोसेस के अंदर कुछ है, डिस्पाइट द फैक्ट दैट ही इज रनिंग विद सच अ ह्यूज टीम एंड हैंडलिंग सो मेनी केसेस देयर। तो सर इस पे जरा 2 मिनट के लिए आप सब लोगों को एनलाइटन कर दो कि हाउ यू नो विदाउट पेन यू आर मूविंग ऑल दिस थिंग देयर एंड हाउ वी कैन improve the image of our IPR. So only for 2 minutes, then we start the main topic.
तो सबसे पहले प्रसाद साहब, मेरा नमस्कार आपको। मैंने पहले नहीं देखा था, आप हमारी इस एसोसिएशन में हमारे कलीग हैं, रिस्पेक्टेबल कलीग हैं। और इसी द क्वेश्चन दैट मनोज जी हैज आस्क्ड मी, how to tackle the difficulties that are being faced by resolution professionals. So let us take the first difficulty is that we don't get new cases. Definitely, this is something which is a very serious concern. One, that there are not new cases much in banks. So therefore, the banks are not having much of the cases. And in this visit of Kolkata, I visited Punjab National Bank. I conducted the physical stakeholders consultation committee meetings. So met 15 bankers. What my feeling is that they don't have cases. So what is the reason that they don't have cases? Primarily, the NCLT was taking longer time. So they decided either to settle, one-time settlement, or they decided to sell it to ARCs. Primarily, that has happened. So therefore, what I'm trying to say is the business has missed it too. Business has been shifted from the public sector banks to ARCs, and some business is also available with NBFCs. So yes. Therefore, our efforts for our presence, we must feel our presence before ARCs and NBFCs, because see, most of the business has gone to them. Secondly, now when this creditor initiated insolvency resolution process is starting, now the banks will use this as surfacey kind of concept. Without going to NCLT, they can appoint RP, and that RP will become administrator to any company. The other company will have in case they feel aggrieved, they will go to NCLT, but bank will not go to NCLT. But for this also, there are a couple of meetings required before the bankers start discussing about CIIRP, and they start even voting for that. Even in those meetings, if you are present, if you guide the banks or ARCs, even in those meetings, whosoever guide them, whosoever will actually कंधे से कंधा मिला के जो बैंकर के साथ चलेगा, उसी को बिजनेस मिलेगा। मेरा ये बात है इस समय, क्योंकि it is not that they simply will pick up your name and then they do it. Now the second major business will come from NCLT members, because NCLT members now will appoint liquidators. In all liquidation cases, in 100% liquidation cases, NCLT members will pick up. NCLT members will pick up the name from their panel. The committee of creditors has got no say in appointment of liquidator. So therefore, the second business now lies with the NCLT member. After the appointment from NCLT as a liquidator, then you can reach out to various other stakeholders and you can present yourself so that you are continued and they don't think of they don't think of changing you. So this is a second way of getting the business now. And the third way of getting the business is join an IPE, because the most of the business, and especially CIIRP, even in the regulations, they are saying that it is recommended that IPE should be appointed as RP in these cases, because in most of the cases, these companies will be operational. And handling an operational company for a solo IP, it is perceived as difficult. Although I don't agree, because everyone has started as a solo, and then the group joined, and then the size increased, everyone. So I would not agree, but that's the market perception is that now the companies which will come in the insolvency, those companies will be operational. And those companies, the perception is that the IPE, which has larger infrastructure, including the infrastructure of accounts and legal, accept audit and valuation. It is expected that all the infrastructure is available with IPE if it is appointed as RP or liquidator or as a support agency, supporting service. So this is one part which actually will, it is how to get the new cases. This is one difficulty. After getting the comments from Prashad sir and my president Manoj, I will go to the other subject, which is the practical difficulties or the image problem. Because this is one subject that I have concluded from my side. I need the comments from Manoj ji, my president, and Prashad sir.
सर मैं थोड़ा सा ये ट्रैक से हट के बात करूंगा बिकॉज आर दिस वेबिनार इज मेनली टू डिस्कस ऑन द डिस्कशन पेपर, तो आई एम जस्ट मूविंग ऑन दैट। और इस पॉइंट को हम डिस्कस करने के लिए हम 6:20 के बाद 10 मिनट रख देंगे, तब हम डिस्कस करेंगे विद ड्यू अपॉलॉजी टू एवरीबॉडी बिकॉज एवरीबॉडी इज हियर टू लिसन टू अस ऑन दैट पर्टिकुलर डिस्कशन पेपर। तो सर ने बड़ा अच्छा आपको हिंट दिया कि आप किन किन जगहों पे नॉक करके बिजनेस ले सकते हैं। और इमेज वाली जो बात है हम लास्ट के 5-10 मिनट्स में करेंगे। और सर सेकेंडली एक मेरी और हम्बल सबमिशन है, यानी कि वी स्पीकर्स की एवरीबॉडी आर सेइंग यस्टरडे कि हमारा भी टाइम थोड़ा सा बढ़ गया था, लेट्स अडेयर टू आईबीसी टाइमलाइन एंड हम 6:30 बजे जैसे आप अपने IIE के अंदर वो जो वीकली वेबिनार्स करते हैं 1 घंटे का होता है एग्जैक्टली, वी शैल हैव द पीस इन दैट वे सो दैट वी बी एबल टू कंक्लूड आवर एट 6:30। सर आई एम अलाउड टू मूव प्रोसीड इन दैट वे?
Yes, yes, please go ahead.
Yeah, I'm reverting back to my screen sharing. Submission of information by the corporate applicant. We are discussing section 10. We have already discussed about section 9 application. Now we are topic 2 was of section 10 application. Now we move to section 10 application, whereby since information related to the books of account, other documents, whereby they have now increased the scope of information to be provided by the applicant under section 10. And what scope they have increased to be provided under section 10, let's move it there. Submission of information by the corporate applicant. A corporate applicant shall furnish the following information along with an application under subsection 1. So and so, following information relating to the books of account for the immediate preceding 3 financial years or so and so, so and so, so and so. List of all bank accounts and so and so. And particulars of assets and all these things details therein. The corporate applicant shall also furnish the following document: details of secured, unsecured, all this thing there. What I feel is that everybody can read what it required therein. What I feel is that this is just to fortify the genuineness of the section 10 application, which we were just discussing before. Sir Anil sir, you came into the picture along with Mr. Prasad, and how fruitful that will be there, only time will tell. But in addition, what is mentioned therein, if any my co-speaker Anil ji or Prasad sir or anyone else would like to add, that should also be made part of the section 10, so that when we appointed as an IRP RP for a section 10 company, because now rules are going to be changed. If I just remind you, but everybody knows that's in the case of section 10, the IRP RP shall be appointed from the IBBI panel rather than as recommended by the applicant. So so that that is there. What sir, any comments from my partners?
I can add a comment.
Yes,
And
sir.
see,
Yes, sir.
if
Please.
if you look at the history, the section 10 applications were actually seen as something which is a scheme from the promoters, and they are trying to achieve something by filing a section 10 application. Therefore, the bench was asking a lot of questions, and that was taking time. So therefore, there is a market perception that section 10 applications are taking too longer, and it is very difficult to get section 10 applications admitted. Now, all this information is pre-decided. if all this information is already submitted to bench, then the bench will be able to give a decision immediately as per the timeline or as per the tradition. But the bench will not stop admission of Section 10 application only for the purpose of finding the reason of promoters coming to insolvency. So this will actually show a lot of change in the perception about Section 10 application. So it is for the betterment. This is
Okay.
what I wanted to add on this. Yes.
Would you like to suggest that any more information be added therein? What has been already prescribed by the
No, these regulations are very nicely drafted, and a lot of time IBBI could get, because this bill has taken a lot of time. So therefore, these are quite a substantive, quite an exclusive list of documents. I don't think the bench would be interested to know any other thing.
ठीक है sir. Let's move to topic number 3 now. Manner of withdrawal of under Section 12A. You know, Section 12A, when initially it was simply perceived that with the after formation of COC with 90% voting, it should be withdrawn. But as Anil sir said earlier, and in fact sir, हमने इसको काफ़ी डिटेल में कवर करा था जो हमारा कल एपिसोड हुआ था कि हमारे जो क्या कहते हैं 12E के अंदर एक लीनियट अप्रोच ली गई बेंचेस के द्वारा, वेयर बाय दे स्टार्टेड allowing settlement and something like that even before admission, and even 12A before formation of COC and all this thing there. So most probably the regulator or government find it that it is not in consonance with what IBC objective is, and now they're curtailing all this thing there. And sir Anil sir, अब आप बताइए इसके बारे में डिटेल में, नहीं तो फिर मैं
I think this is what is the original intent of lawmakers. They originally wanted this to happen. However, the Rule 11 was used initially, and finally this became the practice of using Rule 11 and either providing a stay or any other process. But then the withdrawal too happened even after filing the liquidation application. The withdrawal has happened historically. There are many benches that they have allowed 12A application at any stage. Now, what is important is 90% voting is important. What I feel, there will be some tweaking in the actual practice. Actual practice would be that if 90% of vote even comes after even the expression of interest is invited, you would see that still there would be some benches they would allow withdrawal. That is one apprehension that I have. Secondly, I see if we have to give some kind of modification in the regulations. The one modification is required because in case we see the bank guarantee for the amount till the date of filing of the application before AA. Then finally, if the bank guarantee is invoked and by that time 4 months have already passed and additional CIRP cost has been incurred, there is no way how can we recover that. So therefore, there should be some modification in the proposed regulation where the bank guarantee would be provided to the estimated expenditure till the application is admitted by the or accepted by the NCLT. So that is something which it is presently there is a lacuna, but I don't think this will impact the RPs, because anyone who is interested to come out of insolvency, he will also need RP to file INC 28. INC 28 will be filed by the RP after the withdrawal order. Before filing the INC 28, he can claim that you give me this fees. And in case the fees is not given by the person who submitted form FA, then RP can hold that INC 28. So it is not impacting the RP. But yes, this will be a very big relief from litigations which comes immediately after the admission order. Yes, please. You are mute. You are mute, Manoj.
या लेट मी आई अनम्यूटेड माय सेल्फ सर इसके अंदर कल हमारा एक डिस्कशन हुआ था यू नो वेयर बाय वन ऑफ द पार्टिसिपेंट वाज क्वाइट यू नो सस्पेक्टिकल दैट जो हमारा फॉर्म FA है उसके अंदर शायद लैंग्वेज के अंदर कुछ दिक्कत है वेयर बाय ही वाज ऑफ द ओपिनियन दैट दिस गारंटी हैज टू बी गिवन बाय applicant or CD or something like that but when I deep delve into it this guarantee has to bank guarantee has to be given by the applicant only this is my opinion rather than CD who's asking for the withdrawal, number one. And number two thing I would like to say is that the language of the regulation is that till the time or at the time of filing of the application, all the expenses and this thing there. But when the case goes on, hearings do happen. I think if language can be amended that taking into consideration the future litigation cost also, that I'm sharing with my police there. So that's all, sir. इसमें मैं अब next topic पे आ जा that's a let's read this thing there and if प्रसाद सर and अगर आपको इसके अंदर कुछ और एडिशन लगे तो बताना section 30A withdrawal of application for the withdrawal under section 12A should be made to the adjudicating authority by the RP within 3 days of the approval of the committee of creditors सर इसमें जो विद इन 3 डेज ये थोड़ा सा टाइम बड़ा टाइट है एंड अगर हम इसमें ये प्रपोज करें बिकॉज 3 दिन का पता नहीं चलता हॉलीडे आ गया
No, what do you want to propose? You want to make
7
it
days
5
7
days
days
or 7 days?
7 days
Propose, nothing wrong in it. You have to propose. From IP's angle, you have to ask wherever
that
you
is
feel,
I thought of
wherever
reading
you
it
feel that we can't fulfill the job
नो
within the
नो
time.
सर हमारा इस समय हम जो वेबिनार करते हैं इसके अंदर हम लोग जैसे मैंने कोई प्रपोजल दी आपने दी किसी और ने दी वी डिस्कस इट एट दी शू द कंसेंसस एंड इफ
No, that's what I'm saying. No, if apart from you, if all our other friends
yes
also feels 3 days is not sufficient, you can ask them 2 more days.
okay
They
sir
may not
okay
give
okay
1 week, but
okay
2
sir
more days they may agree. 5 days they may agree.
okay
I
okay
think let us understand what is supposed to be done by the RP. What is supposed to be done? Now, this is the 3 days from the approval of the committee of creditors. Number one, when this form FA would be submitted, it would be submitted along with the bank guarantee or any other mode of payment. Number two, RP will verify all the particulars and will only then the RP will submit it to COC. Then COC will vote on it. Maybe the COC takes 3 days to vote. After that, what is the reason that the RP need more time? And we need to justify that what is required to be done after the COC approval by the RP, other than making that application which he can even prepare when the voting starts. There is no reason which I can find to justify that RP needs more time.
No, RP has to re-verify. No, whatever channels it may come through, before submission, RP has to verify and satisfy. Then only he can present. No, he requires at least according to the date time.
सर
No,
अनिल
sir,
सर
the
मैं इसमें
voting
यहाँ
has been done by the COC only,
सर
and
सर
the
मैं
voting
ऐसे
is done
बताता
through the
हूँ
RP.
सर अब मैं एक बात करता हूँ कोई इमरजेंसी हो गई कंटीजेंसी हो गई स्टाफ चला गया सैटरडे संडे की आपकी छुट्टी आ गई तो अगर यही 3 दिन की जगह 5 दिन का टाइम ले लिया जाए तो आई थिंक दैट विल कवर ऑल दिस कंटीजेंसीज फॉर अस इट इज़ अ रूटीन थिंग इट्स नॉट दैट कि यू आर ए बॉन्डेड लेबर की उन्होंने पास करा और आप ये वोटिंग की बात कर रहे हैं सर आप और मेरा का एक्सपीरियंस है कि ये 2 दिन कहते हैं 3 दिन कहते हैं और महीना महीना तक ये पब्लिक सेक्टर बैंक वोटिंग नहीं करते तो अगर व्हाट आई फील इज दैट लेट्स हैव ए कंसेंसस ऑफ 5 डेज मैं तो थोड़ा सा और ज़्यादा कह रहा था दैट मेक्स नो बिग डिफरेंस अगर हम कर लें तो जस्टिफिकेशन यही है सर कि सैटरडे संडे छुट्टी होती है कोई और पब्लिक हॉलीडे आ गया जब सम कंटीजेंसीज डू हैपन इन द ऑफिस और यू आर वर्किंग लॉन्ग विद टीम मेनी टाइम्स वी हैव सीन दैट यू गेट हैंडीकैप्ड बिकॉज ऑफ द एब्सेंस ऑफ वन और द अदर पर्सन ठीक है सर तो प्लीज एक्सेप्ट माय दिस सबमिशन okay now let's
That's
move to the
okay.
form thank you
Otherwise, you can make one thing, 3 working days you can put.
सर
Suppose
वर्किंग डेज
you
की कोई
feel
डेफिनेशन है नहीं ये
you
हमारे।
correct, but working days are regarded as normally Monday to Friday.
हाँ जी सर।
तो अगर आप सैटरडे संडे बीच में आएगा इसका वजह से 5 days चाहिए, that is not correct.
हाँ जी सर।
Right now they prescribe for 3 days, but entire process may take a 2 days more. With that gauge of calculation, if you go 5 days, you can ask.
ओके सर। सर
Not
इसमें
more than 5 will be agreed by them also. 2 days they will give.
ओके ओके फेयर सर। इसमें जो हमारी जो मीटिंग्स हैं उसके जो रिलेवेंट प्रोविजंस हैं दोज आर गवर्न बाय द कंपनीज एक्ट 2013। और कंपनीज एक्ट 2013 के अंदर जो मीटिंग वीटिंग का टाइमिंग वाइमिंग सब है ना, तो इसमें सर वर्किंग डेज के अंदर कोई डेफिनेशन नहीं है। दे सिंपली गो विद द क्लॉक एंड डेज ओनली। तो हो सकता है फिर वो वहाँ पे हम लोग थोड़ा सा वो बैकफुट पे आ जाएं। तो चलिए ठीक है सर, व्हाट ऑब्जेक्टिव इज देयर दैट इज देयर। तो सर इसमें फॉर्म एफए के अंदर ये somebody pointed out to me, I have just gone through bank guarantee furnished in accordance with the section रेगुलेशन 30A। तो रेगुलेशन 30A बड़ा क्लियर से कहता है कि इट हैज टू बी सबमिटेड बाय द एप्लीकेंट एंड ऑल दिस थिंग देयर। नाउ दिस कंफ्यूजन एज told yesterday by one of the participants is over. Now let's move to topic number 4. Topic number 4, manner of collating claims received from the creditors by the IRP. Even existing sections and relevant regulations are quite comprehensive as far as collating of claims is concerned. Let's see what they propose to change.
Manoj ji, should I say something?
Yes sir, please, you are the main speaker. मैंने तो उसकी तैयारी भी नहीं करी थी।
No, Manoj ji, this is like something that has actually been clarified.
Yes
There
sir.
are many litigations going on which says
Yes, sir.
that the RP is applying his mind. RP is not supposed to apply his mind. RP is not supposed to verify, because the act does not empower him to verify and determine the amount. Earlier, it was only mandated to RP in regulations. And some of the courts are saying that the regulations are subordinate to code. So therefore, the code has given no power to RP to verify and determine an amount. Now, in this particular amendment, now RP has got the power to verify the claim and also determine an amount based on his own judgments, giving ample time, giving ample communication to the claimant, and in case he is aggrieved, he can go to adjudicating authority. Now, there is a time limit of 7 days. RP must do this, because see, there are many claims which comes to RP, and those claims are presently being collated like as submitted. Then, in case it is done like this by the RP, it will be considered as non-compliant. Why? Now it is in the code that he has to verify and determine the amount. Earlier it was collation. The verification word was only in regulations, and that was also not very specific. It was only in one line the word verify was given. The courts, even NCL 80 has actually held many times the RP is not supposed to be adjudicated. Even today, we are not saying that it will be a power of adjudicating, but it is a power of determining the amount. And the aggrieved can go to adjudicating authority. So therefore, this has become an additional responsibility to the RP. Yes, please. I have
Okay.
done.
Okay. Now let me move to the.
Sir, Ankit sir,
yes,
is
sir,
there any
please.
difference between collation and verification? How we can?
Certainly, very
बहुत बड़ा फर्क है,
very big
बहुत फर्क है।
difference.
सर आप बताइए, अनिल सर आप बताइए प्लीज।
No, collation says the one that the figure which is mentioned in the form. Second, various figures are mentioned in the attached documents. In those attached documents, there are interest rates which are also mentioned. Based on all this, you have to collate. Collate doesn't mean only verify one figure with the other, but the collation means based on the documents submitted, you just need to see whether the amount is appropriate or not in the form as well as in the documents as well in the account statement. But if there is any dispute, if there is anything that you can reject or accept based on the insolvency law, that was not within your power earlier. Now, it is within your power to determine the amount, and anything which is apparent that you can also determine, the other person will go for appeal. But if there is any dispute which is pending before any other court, then RP cannot adjudicate. That particular dispute will continue.
सर इसको मैं एक एग्जांपल से बताता हूँ। जैसे फॉर एग्जांपल किसी कोर्ट ने कोई डिग्री दे दी या कुछ और कर दिया, और वो आपने सीडी ने, जनरली हम लोग क्या करते हैं, हम लोग अपने अकाउंट ये जितने भी हमारे पास डॉक्यूमेंट्स आते हैं उसकी लाइबिलिटी अपनी बुक्स के साथ वेरीफाई काउंटर करके, एंड वी इफ वी फाइंड दैट दोज आर मैचिंग एंड ऑल दिस थिंग देयर, इट्स ओके। और अगर किसी कोर्ट ने कोई एडजुडिकेट करके ऑर्डर दे दिया कि ये जो आर्बिट्रेशन अवार्ड है या समथिंग एल्स है जो सीडी ने अपनी बुक्स में नहीं करा या लेटेस्ट स्टेज पे आया, तो दैट बेस्ड ऑन कोलेशन we used to update that particular claim and uphold that particular claim. अब उसके बाद जो चेंज आया है सर ने आपको ऑलरेडी बता दिया है। Let's move to just for the sake of on making you to understand collation, I've given you this example. Okay, now let's move to topic number 5, handling over possession under section 19. This handling over possession is such a topic. जैसे हमारे वहाँ पे जब हम टैक्स की प्रैक्टिस करते थे, सेक्शन 271(1)(c) होता था कि जो हर बारी बजट में अमेंड हो जाता था। सिमिलरली सेक्शन 19 के अंदर नो डाउट वी एज एन आईपीज आर फेसिंग लॉट ऑफ प्रॉब्लम्स। पहले अमेंडमेंट आई, अर्ली इट वाज सिंपली ये लिखा हुआ था 19(2) के अंदर कि 19(1) के अंदर अगर वो बंदा कॉपरेट नहीं करता तो 19(2) के अंदर जाके आप उसके अगेंस्ट एप्लीकेशन फाइल कर दीजिए। फिर एक जो मैनर था, कोर्ट्स केम अक्रॉस दैट कि जो हम लोग वो कर रहे हैं पंचनामा वगैरह बनाए, बिकॉज मैनी टाइम कोर्ट के अंदर जाके ये डिस्प्यूट खड़े हो जाते थे कि वो जो डिफेंडिंग पार्टी जो कहती थी मेरे से आरपी ने मांगा नहीं, जा उसका कोई एविडेंस नहीं है, समथिंग लाइक दैट। Then approximately a year ago this amendment came out to be there, but at the same time some again some problem was there that जो person specified थे अंदर section 19 के अंदर उसका जो था इन्होंने ये जो है स्कोप को बढ़ाया है। सर अनिल सर प्लीज कम फॉरवर्ड विद योर कमेंट्स।
There is not much of change. Earlier, these particular things were mentioned in the regulations, and now the personnel has been replaced by the person. And the person is also defined, and it includes statutory authorities and creditors. So this actually it gives little more power to RP to reach out to statutory authorities, creditors, and ask for the valuation report, ask for the stock statements. So the basic difference is that the RP can now reach out to any person who may have that information, including ex-employees, including consultants, including chartered accountants who are the statutory auditors. Even earlier also we used to do that. And there are many judgments which in fact had been doing it. But to my understanding, this is only make a little change that instead of personnel, it is now persons. So there will be many people who actually also would be covered, like financial institutions, statutory authorities. Even otherwise, it was also covered in regulations.
That means both corporeal and non-corporeal persons are covered.
Yes. According to my understanding, this will not make much of difference.
या सर हाईली एक्सपीरियंस हैं तो ये अपने प्रोसेसेस के अंदर ऑलरेडी इन चीज़ों को यूज़ करते थे, बट जो लोग नए थे तो अब उनके पास ये यानी कि राइट जो है पहले भी था, अब उस राइट को लिख दिया गया है कि आप जैसे किसी बैंक के पास जाते हो तो उसको कह सकते हो भैया आपने जो स्टॉक ऑडिट कराया था, जो आपके मंथली स्टॉक स्टेटमेंट दी गई थी, इन सबको मेरे पास शेयर करो। किसी असेसिंग ऑफिसर आईटीओ के पास जाते हैं, उसने अगर स्क्रूटनी के अंदर कुछ केस करा हुआ है तो ये उसने जो डॉक्यूमेंट सीडी ने सबमिट किया था, यू कैन नाउ आस्क डायरेक्टली बिकॉज नाउ स्टैट्यूटरी अथॉरिटीज एंड फाइनेंशियल इंस्टीट्यूशन वर्ड्स हैज बीन इंक्लूडेड देयर। और क्या क्या मांग सकते हो वो that is something subjective as per your requirement to verify all this thing there. So this is there. Sir Prasad sir, would you like to add something, anything on it?
No, this is a welcoming provision.
This is a welcome. This is for the help of the IPs and just to more
Yes.
do the things smoothen the process of all this thing there.
Yes, yes.
हाँ जी सर, deemed appointment of registered profession in decision of COC and its communication to IRP CD board adjudicating authority. Sir, existing.
Manoj ji, my understanding is it's a very small change.
Yes, sir. Please.
It will only save some time of NCLT it will not change the life of the RP. It
Correct.
is not having any impact on the RP's life or RP's practice. Only one order, which is supposed to be by the NCLT, is saved. Nothing else.
सर अभी बिल्कुल ठीक आपने, हमारी एग्जिस्टिंग प्रैक्टिस भी ये होती थी, जब हम आईआरपी से आरपी बनते थे, बोर्ड के जो सीओसी ने जैसे अप्रूव करा उसकी हम इंफॉर्मेशन दे देते थे, और हाँ अगर चेंज होता था देन वी मूव एन एप्लीकेशन विद ऑल फॉर्म 2 एंड ऑल दिस थिंग देयर टू द दिस थिंग देयर, तो दैट इज देयर। चलिए सर, थैंक यू वेरी मच फॉर गिविंग प्रिसाइज इंफॉर्मेशन देयर। सर मैनर एंड टॉपिक नंबर 7. Topic number 7 is, sir, manner and condition for the transfer of an asset of a personal or corporate creditor of a corporate debtor. As yeah. This is something 26(8), section 28A, CIRP regulations 26A. अनिल सर प्लीज आप उसको बताइए, फिर मैं सप्लीमेंट करता हूँ। मदान सर वेलकम सर, वी वेलकम यू एंड वी मिस यू येस्टरडे, और लेकिन आपने प्रॉमिस किया था कि आप यूट्यूब को पढ़ के हमारे को एनलाइटन करेंगे। तो फिलहाल तो जो इस समय हमारा चल रहा है वेबिनार, अनिल सर बाई चांस उन्होंने लेना था, लेकिन बाई चांस वो किसी जगह पे फंस गए, तो ही इज एट स्टक अप एट एयरपोर्ट इन एन इमरजेंसी, तो वहाँ से ले रहे हैं। तो सर आप जो भी आपकी इनपुट हो, हमने 6 टॉपिक्स ऑलरेडी कवर कर लिए हैं, तो जैसे ही आपकी बाकी जगह पे इनपुट हो, प्लीज गाइड अस एंड हेल्प अस आल्सो देयर। अनिल सर प्लीज
मेरी सिक्स में एक ऑब्जर्वेशन है।
आप बताइए ना सर, बताइए
तो
ना
अभी
प्लीज।
आपने डिस्कस की अपॉइंटमेंट ऑफ डीम्ड अपॉइंटमेंट ऑफ आरपी, that it's not required to be communicated to double A now. Why is it so?
सर अर्लियर वी हैव बीन कम्युनिकेटिंग थ्रू आवर, सर अनिल सर आप बताइए, हमारे ऑफिस में तो ये प्रोसेस होता था कि हम लोग जो प्रोग्रेस रिपोर्ट देते कर देते उसमें कर देते थे।
पहले डबल ए था, डबल ए हटा दिया गया है।
See, like there is only one difference. First of all, Madan ji, namaste.
सभी को नमस्कार।
नमस्कार।
सर ये मैं सर आपको हल्की सी बात बताना चाहूँगा, मदान सर जो है ना, ये हमारे मेंटर हैं, ये आईबीसी बनने से पहले ही नहीं, उससे पहले से भी, तो वी ऑलवेज हैव अ ग्रेट रिगार्ड फॉर हिम, और हम इनको फोर्सफुली कहते हैं कि ज्वाइन करा करिए डिस्पाइट हिज हैवी शेड्यूल। यस सर प्लीज, यस सर प्लीज।
तो लाइक ओके, मैं तो मदान साहब की नमस्ते में टॉपिक ही भूल गया। सो
एडजुडिकेटिंग अथॉरिटी को इन्फॉर्म करना।
So, पहले it was required that the adjudicating authority will pass an order. Then it is removed by the code. Now, IBBI by regulations now again says that the adjudicating authority must be informed. Now, why IBBI says that it must be informed, which probably was missed by the select committee as well as the lawmakers in the Ministry of Corporate Affairs. Now the NCLT must know whether the IRP has actually been appointed as RP or not. Only for that purpose, it is said that you must communicate to NCLT. The only issue is, whenever we communicate to NCLT, now many bench says that it has to be submitted as an IA, along with 1,000 rupees fee. And it will also be listed like the progress reports are listed. What I fear, and I will ask from Madanji, that in case we have to inform anything to NCLT, NCLT will ask us to file an IA along with 1,000 rupees. It will also get listed and it will be taken on reform. This is what is my understanding. Whenever we say inform, earlier it was an order to be passed, now it has to be placed on record. Madan ji, आप थोड़ा clarify करिए।
बिल्कुल ठीक है, लेकिन पहले भी क्या होता था, an application to begin with, the application was not required to be filed, it was to be intimated. Later on, any intimation to NCLT goes by way of an IA. आई थिंक वो 1,000 रुपीज वाला कंसिडरेशन है कि एनसीएलटी का कुछ ना कुछ रेवेन्यू जनरेशन होना चाहिए। इवन विद द प्रोग्रेस रिपोर्ट यू आर फाइलिंग एन आई अननेसेसरी, दैट्स नॉट रिक्वायर्ड एनीवे। But now, earlier the provision, if we read this proposed the amendment, it says for the words, the COC shall communicate its decision to IRP, the CD, and adjudicating authority. अब इसकी जगह रिप्लेस होके क्या आ रहा है, सच पर्सन शैल बी डीम्ड टू बी अपॉइंटेड एज द आरपी फ्रॉम द डेट ऑफ सच रेजोल्यूशन एंड दिस डिसीजन शैल बी कम्युनिकेटेड टू आईआरपी, द सीडी एंड द बोर्ड। डबल ए हटा दिया गया, बोर्ड ऐड कर दिया गया है। व्हाई दिस इंटीमेशन शुड नॉट गो टू डबल ए? हाउ डबल ए विल कम टू नो दैट हु हैज बीन अपॉइंटेड एज आरपी नाउ? I think, in my view, only board should have been added. Now board has replaced double A. That should not have happened.
Okay.
Finally,
Sir,
finally, Madanji, in regulations, the IBBI has further proposed that it will be informed to adjudicating authority also.
Because sir, Amendment
Because-
Act में ये गलती हो गई है, उस गलती को rectify किया जा रहा through regulations now.
Absolutely. This is what I said. I said that probably that it was missed by the code, so therefore it has come in the regulation.
But
Anyway,
at
information-
the discussions they brought to the notice of the government, and unfortunately वहाँ से भी notice हो नहीं पाया लगता है.
अच्छा, जब select committee को represent करते हुए आप गए थे.
But not very important subject. I think we can move on.
Yeah.
There are many.
No, many others. Sir, we are, the topic number 7 we come for, again now. Sir, time थोड़ा सा sir कम रह गया है, तो जरा थोड़ा सा
इसलिए मैं जल्दी करता हूँ.
आप ही को मैं सीधा दे दूंगा, मैं अपने कमेंट नहीं देता, because that will save the time. Sir, अब ये 26A 28A के बारे में जो आया है, ये manner of condition of transfer of the assets of a personal to corporate guarantor of the corporate debtor as part of the insolvency decision process. Sir, ये थोड़ा सा सबको highlight कर दीजिए.
So there are many cases. So there are many cases. It so happened in India that there was a land available, and that land was available with any of the promoters. Then a company was formed, loan was taken, and there was a default. So the land was separately mortgaged to banks, and the building and the factory, everything was running in the name of the company, private limited company or LLP. So in the case of default, it was not possible that this particular land becomes part of the resolution plan or it becomes part of the liquidation estate. Although for the liquidation estate, there are not many NCLAT orders, so we are selling in liquidation all assets collectively. But in resolution plan, there is this is a amendment which is actually a very significant amendment. That first of all, one condition that the asset must be in the possession of the creditors, either under section 13(4) of the SIRP law, or under section 29 of the state financial corporations, or any other law. It must be in the possession of the secured creditor, whosoever has the charge on that asset. Now, the possession, as far as the SIRP law is concerned, there are two kinds of possessions. One is a symbolic possession, and the other is a physical possession. So since it is not physical possession, so what we are assuming that even symbolic possession is also included. So this is one part. Then the committee of creditors must decide by 66% voting that this particular asset will become part of the resolution plan. Then the difficulty number 1, which was envisaged. Let us understand the secured creditor, State Bank of India, who has the charge on the land. So he would first of all agree that yes, I am ready to put it on the resolution process. Then he will also put a condition that I would like to get this valued. Then he would like to put a condition that how the proceeds will be distributed. All this has to be decided between the committee of creditors. Then only this asset can become part of the resolution plan or resolution process. But in case the asset is owned by another corporate guarantor, and that corporate guarantor is also under CIRP, then that CIRP guarantor CG's CIRP, and the RP will also pass a resolution. Then that asset actually will come to the main CIRP, where the asset has to be collectively resolved. And then the COC, both COC and both RP will interact to decide what is the value of the asset, how much and in what manner the resolution proceeds will be distributed. All this has to be decided before this can be activated. What my understanding it is very useful, but it has to be applied very carefully.
Sir, sir, 6:09 हो गए, तो मैं without my comments, I am practically facing इसके अंदर अगर बाई चांस एक ही क्रेडिटर है, जैसे मेरे एक पर्टिकुलर केस के अंदर स्टेट बैंक 100% क्रेडिटर है, और उस केस के अंदर तो ये बहुत बेनिफिशियरी है. दैट्स ऑल. Manner of payment of debts, topic 8. Manner of payment of debts of financial creditors who don't vote in favor of the resolution plan. Sir, Anil sir, please.
Very significant amendment. Now, if you see, first of all, the liquidation value means the amount which will be distributable to the dissenting creditor in case the company is liquidated. Number one. Number two, in case the resolution plan is for an amount which is one amount, and in that resolution plan, the amount is A or B. So there are two amount, A or B. One amount says in case the company is liquidated, what would be the amount due to State Bank of India. The other is if the resolution plan is more than the liquidation value, then lower of the two, more or less, lower of the two will be distributed to State Bank of India in case the State Bank of India dissents. Now, in this case, there are two impactful thinking that we actually have to consider. Number one, the definition of security interest. Number two, the clarification on Section 53. The clarification on Section 53 says that the secured creditor will be secured creditor only to the extent of value of the security interest. So that means the secured creditors, in case there is a company, that company has liquidation value of 100. Therefore, the secured creditors cannot be more than 100. Secured creditors cannot be more than 100. It can be less than that. It cannot be more than that. If all the assets of the company are charged to creditors, then the secured creditors, total secured creditors cannot be more than a liquidation value of the company. Rather, it can be less. So if there is no, see, like then now it is very clear that is the amount which is distributable to State Bank of India. And in case the resolution plan offers less, the least of the two, the impact of this particular amendment that nobody would get benefited by becoming dissenting creditor. Only that person will become dissenting whose security is very high and he actually the debt is less than even the value of the security. Only in that case he would become a dissenting creditor, and the rest of the money will go to the rest of. So this is what is my observation on this. I think if Madanji can add something, otherwise we can move. Or Manoj ji, you can add.
नहीं सर, मैं टाइम बड़ा कम है, मैं कुछ ऐड नहीं करूंगा. आई शैल मूव फॉरवर्ड. मदान सर एंड माय प्रसाद सर, सर आई रिस्पेक्टफुल सबमिशन इज, आप प्लीज जैसे ही टॉपिक खत्म हो तो अगर आपको कुछ ऐड करना हो तो यू इंटरफेयर इमीडिएटली.
अनिल जी जब बोल रहे हैं तो कुछ बोलने, किसी और को कुछ कहने की जरूरत नहीं.
सर फर्क है सर,
नहीं, मदान साहब.
हम लोग प्रोसेस रन
गागर
करते हैं.
गागर में सागर है अनिल जी.
सर हम प्रोसेस रन
अरे
करते हैं, आप वकील हो, आप हमारे प्रोसेस को कोर्ट के सामने जाके वो दिखाते होगी हमारा ठीक है. और
नहीं,
प्रसाद सर क्यों
मैं मनोज जी दूसरी बात कहूंगा. हम दिन में लीगल के ऊपर टाइम स्पेंड करते हैं 1 आवर, बाकी सारा
ये
टाइम
तो
हमें
आपका
कोऑर्डिनेशन
अलग अलग एक्सपीरियंस है.
बैंकों के साथ कोऑर्डिनेशन, ये सब. मदान जी लीगल के ऊपर स्पेंड करते हैं टाइम दिन में 10 घंटे.
हाँ जी
ये
सर.
तो फर्क आपको मानना पड़ेगा जी.
सर यही तो मैं कह
लीगल
रहा
के
हूँ ना,
बारे में
ये
ये
फर्क है
बिल्कुल लीगल इशू है जो मैंने अभी बोला
हाँ
है.
बोला है. और सेकेंडली सर प्रसाद सर ड्यूटिकेट करते हैं, तो आप लोगों का अपना ही पर्सपेक्टिव है. मेरा और अनिल गोयल सर का बिल्कुल प्रॉपर है कि यू आर रनिंग द प्रोसेस. तो चलिए सर.
लेट्स कन्फाइन द प्रोसेस ओनली टुडे. लेट्स फिनिश इट.
चलिए सर, थैंक यू वेरी मच. ओके. कंडीशन एंड मैनर ऑफ कॉन्स्टिट्यूशन ऑफ कमिटी टू ओवरसी इम्प्लीमेंटेशन एंड सुपरविजन. सर ये अनिल सर प्लीज.
Not much of change. It is only in the code now. It is an official power of implementing, and the RP or any other resolution plan is mandatory. And however, still there are SRAs. They still kind of argue on the duration of the monitoring committee. There are cases the SRA says that I have paid the money, and the distribution disputes will continue. Why the IMC should continue? I have paid the money. It is implemented completely. You have handed over the asset to me, but there are disputes. Why should I continue the IMC? There has to be a separate provision that if SRA is completely satisfied, but there are distribution disputes, there are disputes on various other assets which are not part of the resolution plan, there are disputes about the avoidance transactions, who will, the law says that the resolution plan must provide for it. The resolution plan provides for it as far as the implementation part is concerned. A resolution plan in future must provide that in case there is anything left, the monitoring committee will discontinue, but there has to be some structure who will continue with the avoidance transaction, who will continue with the distribution disputes. So this is something which is still missing, that who will continue, because the SRA says that I have paid the money, I have taken the possession, you have handed over to me everything, I have become director and the shareholder. No, the monitoring committee is dissolved. But this part is still pending. Who will continue for all these things that I've said?
सर इसकी जो हम लोग करते हैं वो बेसिकली जब हम प्लान देते हैं उसके अंदर हम डाल देते हैं कि एट व्हाट मोमेंट द मैनेजमेंट विल बी हैंडेड ओवर टू द एसआरए। जो आज की डेट में जो चल रहा है, इवन अगर आप 70-80% तक भी पेमेंट कर दो तो बैंक्स आर जनरली विलिंग टू हैंड ओवर द पोसेशन टू यू, लिविंग साइड अगर कोई डिस्ट्रीब्यूशन का डिस्प्यूट आ रहा है तो वो है ही है। तो दिस इज ओनली आई हैव टू ऐड। सॉरी सर, 16 मिनट हो गए, हार्डली 40 मिनट्स आर लेफ्ट और अभी हमारे 3 टॉपिक्स हो रहे हैं। फॉर्म मैनेजर कंडीशन ऑफ द ड्यूटी अथॉरिटी टू फर्स्ट अप्रूव द इम्प्लीमेंटेशन ऑफ द रेशन प्लान एंड देन द मैनर ऑफ डिस्ट्रीब्यूशन। अनिल सर प्लीज।
Manoj, in this case also there is a condition that the committee of creditors must decide this process by 66%. Tell me which is the COC which will decide that you approve the resolution plan, let it go to the SRA. We don't see, like, we will hand over everything. We will also give them the NOC. The SRA will continue to take loans, process and implement, but we will get the distribution much later. The COC will not resolve this, and without resolution of the COC, this is not implementable. Earlier, the benches used to do that. Benches used to think, let me approve the resolution plan, let it be implemented, and the distribution will follow. That is still happening. In many cases of mine, it is happening. But in this case, it requires 66 for voting, but nobody will vote for this kind of structure, that everything is done, but the COC will not get money.
बिल्कुल, आई एग्री विद यू सर। वो तो यानी कि शार्क की तरह पैसे के ऊपर बैठे होते हैं कि कैसे हम अपने मैनेजमेंट को सेटिस्फाई करेंगे कि हमने इस प्रोसेस से इतने पैसे बैंक के लिए निकाल दिए। आई फुली एंडोर्स योर व्यू। ठीक है सर, नाउ लेट्स मूव टू टॉपिक नंबर 11, मैनर कंडीशन फॉर द COC to apply for restoring the CIRP and the manner and condition of completing the restored process. Sir, please.
Now, the sale of the company during liquidation process is deleted from the law since 14th of October 2025. There is only one process which is going on under Section 230 of the Companies Act. Now, the Companies Act amendment and proposed amendment. Proposed amendment is also proposing to remove that word from Section 230, that the liquidator also can resolve it through the creditors' compromise and settlement. Now, if that is also removed, then all these regulations will be withdrawn. But what I'm trying to say, it is only a window for about 1 or 2 months. The application for liquidating the company is filed. In the meantime, some opportunity comes, and then only we can file an application. On one side, the law says that the liquidation application should be approved within 30 days. On the other side, we are saying that within this 30 days, in case there is any opportunity which comes, then you can apply, and then you can actually get the approval from the NCLT and again restart the process for 120 days. But this window is too small. That means 1 month window. If there is any opportunity which is coming, which may or may not come within that small period, or alternatively, it is being perceived that the application for liquidating the company will stay for longer before AA. That is what is my observation.
Okay, this particular provision has been brought against Honorable Supreme Court judgment, whereby in one particular case, the company was under liquidation. They said that let it be restored for CIRP, most probably keeping spirit in that particular decision. That is there. Now, sir, let's move to condition for dissolution of the corporate debtor. Anil, sir, please.
Now, see, the committee of creditors presently can decide in the very first meeting also that this company may be liquidated because of there is no asset, or there are some kind of other observations that there was no business, there is no technology, it's all obsolete. and there is no asset. All these reasons the COC can give, and the COC can liquidate the company. But now, although there was orders, actually the COC can directly dissolve also. And there are orders which are actually successfully, it was dissolved. But now it is in the code that the COC has the power to dissolve the company rather than liquidating, so that the liquidation process is saved and the cost of liquidator is saved, cost of liquidation is saved. My only apprehension is, I will give you an example. One example is that there was a company 3 years back. It was a company with 500 crore. Then something happened because of the management disputes or whatever. Whatever 500 crore was there, that was siphoned out by the promoters or by their. After siphoning off, the company had no asset, and the creditors were not getting any money. Now, in case the COC decides today that there is no asset in this company, and the COC decides to dissolve the company, then what about the fraudulent? What about the undervalued? What about the preferential? So what I mean to say, that whenever COC takes a decision to dissolve the company, right at the first meeting of the committee of creditors, it should also think whether all the claims have been filed or not. Number one. Number two, if the claims have been filed, whether there is any creditor who is kind of aggrieved from fraudulent transactions, or any creditor who sense that fraudulent transactions have happened. So in case all this have happened, then the COC will not approve dissolution of the company. Rather, the COC will say, go ahead, appoint an auditor, highlight the transaction, file an application, and then liquidate the company. This is what is my observation.
सर इसमें मैं एक ही बात ऐड करना चाहूँगा कि ये वाला जो प्रोविजन लाया गया है ये इस ऑब्जेक्टिव से लाया गया है. मेनी अ टाइम्स कंपनीज कम आउट टू बी देयर वेयर बाय 1 करोड़ की थ्रेशोल्ड लिमिट ही कर रही होती है और कोई टेंजिबल या इनटेंजिबल एसेट होता नहीं है. तो उसकी जो लिक्विडेशन कॉस्ट कह लो या CIRP कॉस्ट कह लो, वो एग्जिस्टिंग एसेट से भी काफ़ी ज़्यादा बढ़ रही होती है. जस्ट टू कर्टेल दैट पर्टिकुलर कॉस्ट. Earlier provision was already there of liquidation. Now, by adding dissolution based on the adjudication done in this way is there. सर ने जो बात करी 500 करोड़ एंड ऑल दिस थिंग देयर, तो उसमें जो फ्रॉडुलेंट के अंदर अगर पकड़ा गया, रिकवरी आई 43, 45, 47, 66 या जो भी रिलेवेंट सेक्शंस हैं, तो अगर कुछ आया तो वो तो वैसे भी सर कंपनी लिक्विडेट हो जाती है और NRI करके उसको भेज दिया जाता है, और कुछ मिल जाए तो ठीक है. अदरवाइज जो रियल ऑब्जेक्टिव था वो यही था कि जहाँ पे कोई एसेट्स है नहीं और टेंजिबल इन द सेंस की जो लिक्विडेशन कॉस्ट एंड CIRP कॉस्ट है वही बर्डन ना बने ये इनके ऊपर फाइनेंशियल क्रेडिटर्स के ऊपर, तो उस चीज़ को करने के लिए करा गया था. सर इन माय ओपिनियन,
My only observation is that,
यस सर,
see, number one, that in case the company is dissolved in the very first COC meeting or in the second COC meeting, how all these avoidance transaction will be highlighted and proceeded against.
सर मैं ये
COC,
हाँ जी सर,
if the COC decides that let it be happen, because see, there are companies where everything has been taken away, and they are taken away by the erstwhile management, and now they want to dissolve, they want to close everything. It is only in those cases that the COC has to be very, very careful. Otherwise, this can lead to all whatever crime has happened. It will be a kind of effort to bury the crime without
ओके
taking
ओके ओके
actions.
ओके 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 ओके. तो ठीक है सर का अपना परसेप्शन था, मेरा परसेप्शन था, मैंने करा कि इस प्रिज्म को लाने के पीछे जो ऑब्जेक्टिव था वो ये था. बट अनिल सर इज लिटिल बिट एप्रीहेंसिव कि दिस पर्टिकुलर बेनिफिट शेल बी अब्यूज्ड बाय सम मैनेजमेंट. तो ठीक है सर, लेट हमारे जो प्रसाद सर हैं, जब इनके जो कलीग्स हैं दे विल टेक केयर ऑफ इट कि जो हम इस तरह की COC प्रूव कर रही है, या पहले तो COC प्रूव करेगी नहीं करेगी, और उसके बाद जब ये इस तरह की सिचुएशन है तो डिसोल्यूशन बी अलाउड और नॉट अलाउड. और अगेन डिपेंडिंग अपॉन मदान सर फेस एंड इन फ्रंट ऑफ द बेंच, कि बिकॉज बेंचेस के अंदर मेनी टाइम्स काम फेस वाले पे होते हैं कि वेदर दे बी एबल टू रूट इट थ्रू और नॉट. चलिए, दिस इज वी अंडरस्टूड द बेसिक प्रोविजंस देयर. ओके सर, नाउ लेट्स मूव टू टॉपिक नंबर 13, रिलीज ऑफ गारंटी इन द रेजोल्यूशन प्लान.
It is very simple that the guarantee or the corporate guarantee, personal guarantee or the corporate guarantee will not become part of the resolution plan. Guarantees are supposed to be dealt with separately. Corporate guarantees are supposed to be dealt separately. There is no, because if there was some resolution plan, they actually carried all this. Now the government is very clear that the guarantors are separately proceeded against, corporate guarantors are separate, and the resolution of the company is separate. So the resolution of the company should have only one objective, that is to revive the business, not to give some kind of a relief to guarantors. So if the business can be revived, then resolution. If the business cannot be revived, the resolution plan will not attend to giving relief to guarantors. That is the very important subject which is caught here.
Sir,
ठीक है सर।
even though the resolution applicant is promoter of MSME,
Even if
but
the
then
resolution, the name resolution is for the business, not for the guarantor. That is
that's
what is the
fine.
message.
Sir, if a MSME promoter is giving a resolution plan, he would like his guarantees to be released. If he is giving the proposal, COC is in agreement, why should it not become within the ambit of the resolution plan?
I think this is a consensus amongst the lawmakers that if there are avoidance transactions pending, even MSME promoters should not be brought back to the company by just using 240A section.
That's a separate issue. Here, my question, suppose avoidance is not there, and simply because his PG is there, personal guarantor of the personal guarantee of the promoter of MSME CD is there. He is giving his plan, and one of the conditions is okay, the settlement is subject to this PG shall be released, and COC is also agreeing with that. It's like a one-time settlement or corporate debt restructuring. Why should it be stopped there?
I can only say the intent of the lawmakers. The intent of the lawmakers are that they are saying they have got the feedback that there are many MSME companies. The promoters are coming to COC to resolve the debt, and their main intent is to safeguard themselves from their personal assets, from their personal bankruptcy, and they are not worried about resolving the business. So therefore, they are not trying to combine these two things separately. In case the PGIP has to start, PGIP has to start, bankruptcy has to start, that can separately be settled with the creditors. Nobody can stop them. But the resolution has to be exclusively for the business, for the company, for the productivity, for the workers, not for the promoters.
सर इसमें मैं एक ही बात ऐड करूंगा सर। देखिए अनिल सर, ये बड़ा सब्जेक्टिव सा मैटर है। अगर हम इसी चीज़ को थोड़ा और ब्रॉडर वैसे देखें तो हम मदान सर के पास पहुंच जाते हैं। आईबीसी का ऑब्जेक्टिव क्या है? सर्वाइव करना। सर सर्वाइव करने के लिए एंटरप्रेन्योर को भी सर्वाइव करना पड़ेगा आपको। और एमएसएमई के केस में ये देखा गया है कि आपको नया कोई बंदा मिलता नहीं है, जो पुराने प्रमोटर्स होते हैं वही कंपनी को बेटर चला पाते हैं। तो अगर हम इसको ब्रॉडर एंगल से देखें तो जो गारंटी का ना अलाउ करना, दैट मे बी अ लिटिल बिट हैम्परिंग, बट इन एनी केस सर वी रिस्पेक्ट योर सेइंग आल्सो एंड रिस्पेक्ट द सेइंग ऑफ मदान सर आल्सो। लेट्स मूव फॉरवर्ड, हार्डली 2 minutes are left now.
Yes.
सर हम आपके यहाँ पे बैठ के ना क्या कहते हैं अनिल सर, पूरा का पूरा कलकत्ता का नज़ारा देख रहे हैं। जो हम न्यूज़ वगैरह में सुन रहे थे कि वहाँ पे आज इलेक्शन डे है, फाइट हो रही होगी, ये हो रहा होगा, वो हो रहा होगा, बट बिहाइंड यू वी आर सीइंग लॉट ऑफ गुड फेसेस एंड लॉट ऑफ एक लॉन्च पे बैठे हैं तो डेफिनेटली वहाँ पे तो लड़ाई वाली कोई बात नहीं होगी। तो फॉर दैट एक्स्ट्रा एंटरटेनमेंट वी आर रियली थैंकफुल टू यू।
मनोज जी, गुड फेसेस नहीं है, बैक है, ऐसा मत कहो। देखो
बैक है
सर पता क्या बात है, अब हर चीज का ना ग्लास आधा खाली आधा भरा हुआ है। मैं तो सर हमेशा भरा हुआ देखता हूँ। मेरे को तो फेसेस अच्छे ही नजर आए हैं, हो सकता है आपको बैग नजर आई हो। इन एनी केस सर, इट्स ऑन द लाइटर साइड। तो
मदान जी अपनी अपनी पसंद है।
नहीं सर, मदान सर सर अब टॉपिक नंबर 14, नोटिफिकेशन ऑफ फॉर्म्स और सर्कुलर्स। सर ये
तो
एक लाइन का प्लीज एनलाइटन कर दीजिए।
आईपीएस के लिए एक नया और चीज आ गई जिसको उनको देखना है। जब भी उनको कोई चीज स्टडी करनी होगी, पहले वो he will see code, then he will see regulations, then he will see circulars. Then only he would be able to conclude what is the present law.
Correct.
Now, finding the circulars, it is not easier as we find the judgments on regulations as we find judgments on sections. It is very difficult to find judgments on circulars. It is very difficult to kind of prepare a search engine which actually will include circulars on that subject. Not many I have seen. Whenever I go to ibclaw.in or scc.com, if I search, I only will get the judgments based on the sections or regulations. I will not get the judgment based on the circulars. That is the only difficulty I have, because that is the third thing that I have to add now in my search to conclude about a subject. प्रसाद साहब
सर या इसके बारे में सर मैं आपको एक बात कहूंगा, ये कहते हैं ना फिर वही बात, आधा ग्लास खाली आधा भरा हुआ। मैं इसको इस एंगल से देखता हूं कि पहले हम लोग सेमिनार्स और वेबिनार्स करते थे व्हेन एवर देयर इज एनी चेंज इन रेगुलेशन और कोड। अब सर नोटिफिकेशन पे भी जब मटेरियल हो जाएगा वो भी आएगा, तो तब हमारे को और अपॉर्चुनिटी मिलेगी इस तरह के वेबिनार्स और सेमिनार्स करने के लिए, सो दैट वी कैन एजुकेट आवर को फ्रेंड्स। तो सर एक तो ये पार्ट हो गया। दूसरा पार्ट ये हो गया सर, सेम प्रॉब्लम वी आर फेसिंग, बट आज की डेट में मार्केट के अंदर एआईज बहुत अच्छी अच्छी आ गई हैं, वो एआईज आपको सर्कुलर तक भी ले जाती हैं। दैट इज माय सबमिशन लॉन्ग विद टू यू। तो सर अब उसमें आई एग्री विद यू कि आईबीबीआई ने अपना बर्डन कम करने के लिए रेगुलेशन को लाने के लिए उनको पहले डिस्कशन पेपर देना पड़ता है, पब्लिक कमेंट्स मांगने पड़ते हैं, उसको रिड्यूस करने के लिए दे आर कमिंग आउट विद दिस थिंग देयर, एंड इन देयर ओपिनियन जो फॉर्म्स के अंदर चेंज होता है दैट इज नॉट मटीरियल, इट इज नॉट रिक्वायर्ड टू बी हैव सच अ डीप थिंग देयर। तो सर दिस इज फ्रॉम माय साइड। 1 मिनट ऊपर हो गया है, मेरे को स्टार्ट होने से पहले सर ने कहा था, प्रसाद सर ने, आप इसको 6:30 पे खत्म कर देना। मदान सर, प्रसाद सर, विद योर क्लोजिंग कमेंट वी क्लोज ऑन द मीटिंग। अब जो पीपीआईआरपी रह गया, जो वो वॉलंटरी लिक्विडेशन रह गया, आई अपोलोजाइज टू माय माय को फ्रेंड्स हियर, माय टीममेट्स हियर इन द वेबिनार। हम उसको फिर किसी समय और ले लेंगे। नहीं सर, सर उसका भी सर 1 मिनट, उसका भी एक सोल्यूशन है हमारे। ये क्या नाम, अनिल गोयल सर हर सैटरडे को सुबह 11 बजे वेबिनार करते हैं, तो मोस्ट ऑफ वो इसके अंदर इन चीज़ों को ले लेंगे, बिकॉज इन्होंने ऑलरेडी मेरे को कहा था कि मैंने इसको प्रिपेयर करा है। तो आप वहां पे भी जाके इनको थोड़ा सा देख सकते हैं। तो आज जैसे वी वाला हार्डली 2 days आर देयर, तो हम इसके ऊपर लग से वेबिनार सेमिनार नहीं करेंगे। तो अनिल गोयल सर की इनकी भी जो है सैटरडे को जाके, तो दैट विल
purpose is to give inputs to all people. So here or there, if need is served, that is enough.
सर हमने बताना होता है ना कि ये पर्पस है। अब रही एक ऑन द लाइटर साइड कि जैसे मैं और मदान सर अपन तो थोड़ा सा फाइट कर रहे थे कि फेस नजर आ रहा, बैक नजर आ रहा है। इस समय फेस भी नजर आ रहा है और बैक भी नजर आ रहा है।
दोनों को कुछ ना कुछ नजर आया, वही दैट इज
सर इस समय फेस भी नजर आ रहा है, बैक भी नजर आ रहा है।
both of your eyesight is perfect.
सर प्लीज गिव योर क्लोजिंग रिमार्क्स सर, प्रसाद सर एंड मदान सर, एंड देन वी क्लोज द मीटिंग प्लीज।
उसमें सर इमेज को टच कर लीजिए, बिकॉज इन द बिगिनिंग यू सेड दैट लास्ट 5 minutes में आप इमेज के बात करेंगे।
ये अनिल सर 2 minutes फॉर इमेज, 2 minutes,
not more than that from Anil sir on image.
I think to all my like colleagues, I would first say that it is very important to clarify that Manoj ji or I, whenever we make any video, there is no revenue model in that. Because see, YouTube revenue comes only in case you have larger audience. Whatever we are doing for the last 4 years, our YouTube channel is only having 6,000-7,000 subscribers. The YouTube revenue comes after about 1 lakh or so. So we get zero from YouTube. So it is our effort to update our own knowledge. And the timeline, the kind of discipline that we have added in our life, that every week we have to spend 1.5 days on this learning. So this is not that it is for any benefit, it is for our own learning. It is my way of learning, you can say. That is what is my slogan. As far as this image is concerned, now the image, 1-2% people, they actually spoil the image. And there are, in fact, this has happened. And also, let us understand, if there is anything wrong which happens, nobody will say that the COC did not act appropriately. Nobody would say that the COC did not approve the cost. So nobody would say that the COC has taken 21 days in passing a resolution. The COC has not contributed. the RP was working without any fund. Nobody will look into this. RP has not been able to do this. That is the only allegation. Very simple, very one-word allegation. Because IBBI is not supposed to be blamed. The promoters are in any case being blamed, but they are not they are only blamed by everyone. But the only person who actually can be blamed is the IP. So to improve the image, as I said in the last time also, we should have more members in our association. Then we should have our chapters in all 4 or 5 regions or zones in India. Then we should actually invite sponsorships, and whenever there is any change in NCLT or any change in IBBI, we should actually give them thanks. We should also give them the welcome. What I'm trying to say, when we actually will appreciate somebody, we will appreciate somebody's work, we would also humbly submit the difficulties faced by the RP, so that these difficulties will actually go into the ears of the people who think otherwise about IP. So in case we keep on doing this, if the advocates, if Madan Sahab can do this in the Bar Council, that whenever there is a new member comes or new member goes, the Bar Council arrange for a very small party and everybody comes. When an association of insolvency professionals will also do that, they will start coming. Maybe initially Manoj ji will have to work a little harder. We will also be with Manoj ji to go and invite people, but it is very important that we should do that. This is what is the way that we can improve our image. Of course, when I say this is another part, the other part is by improving our understanding, by acting fast, and by, of course, maintaining the complete discipline about ourselves, about any greed. That has to be controlled.
I fully endorse sir's view to what he said about improvement of the image. सर ने ये बात करी तो हम लोगों ने एक डिसाइड कर था कि हमारे पास जब मेंबरशिप स्ट्रेंथ 500 के करीब हो जाएगी, जब उससे और बढ़ जाएगी, देन वी शैल हैव ऑल दिस थिंग देयर. But fortunately or unfortunately, IPs are not coming with us, despite the fact that we are taking these webinars or seminars free of cost, and in fact we are paying out of our pocket, but we don't mind in that way. That's something very small. Staff, infrastructure, all we are doing this. कहने का मतलब ये है कि आईपीएस हमारे से एक्सपेक्ट तो करते हैं कि हम लोग जाके अथॉरिटीज के साथ करें. हमने अथॉरिटी के साथ मीटिंग भी करी है, एंड देयर हैज बीन सम रिजल्ट्स आल्सो. और उसके बाद कुछ अमेंडमेंट्स भी ऐसी आई हैं जो ये हमारी सजेशंस के ऊपर आए हैं. बट एट द सेम टाइम वी शुड आल्सो गेट यूनाइटेड. अब हम लोग यूनाइटेड क्यों नहीं हो पाते, उसका भी एक बहुत बड़ा रीज़न है. आज की डेट में 4,500 के करीब आईपीएस हैं. काम करने वाले जो बंदे हैं हार्डली 500 हैं, इससे ज़्यादा है ही नहीं. 500 में से ही 100 के करीब बंदे हैं जो रेगुलर वे से अच्छा काम कर रहे हैं, और उसके बाद जो 500 से लेकर 1000 के बीच में है, एक आधी असाइनमेंट आ गई, दाएं बाएं करके आ गया. व्हाट आई मीन टू से इज दैट कि इफ यू लुक पैरेलल टू आवर इंस्टीट्यूट ऑफ चार्टर्ड अकाउंटेंट ऑफ इंडिया, they also started humbly in this way, but at present they are the largest institute of the world, not of this country. They have a membership of around 2.5 lakh and 5 lakh student or things there. हमारा जो आईपीएस का जो यानी कि जो काम का सफेयर है, जो मार्केट साइज है, काफ़ी छोटा है, और उसके बाद फिर स्क्यूड भी काफ़ी है. This is because of any reason. Only few IPs are able to knock to the particular banks and able to get some work, which maybe me also, Anil ji also, and others also. Madan sir, हम सब लोगों को represent करते हैं among all these things there. But leaving aside all these things, हम लोग फिर भी कोशिश करेंगे, हम लोग फिजिकल मीटिंग्स करेंगे दिल्ली के अंदर. लेट्स गेट टुगेदर, मे बी इन माय ऑफिस और मे बी इन अलीज ऑफिस और समवेयर एल्स आल्सो, और इस तरह का कंसेंसस बना के आगे बढ़ने की कोशिश करेंगे. मदान सर, वोट ऑफ थैंक्स फ्रॉम योर साइड, एंड लेट्स कंक्लूड. वी ऑलरेडी exceeded 9 minutes.
Before that,
yes sir,
before
please.
that, what I suggest is,
yes
let
sir,
us list out what are the common errors professionally committed by IPs, if possible.
yes sir.
And what are the ways to prevent that?
Okay,
common
sir.
errors committed or common errors that they generally commit, and how to prevent them.
Okay sir.
That
Madan
will
sir,
be,
please come forward.
that will be a guiding document.
Okay,
so
okay.
that it is one way of building the image. Second one is, instead of being an individual IP, as Anil rightly said, entities have been now preferred by the stakeholders. So, being stiffly alone, let us come together as much as people come together in like an entity. Entity strength is always different from that of individual strength. And entity's image can be better than that of an individual's image. So entity people should form and IP should form like entities to build up their image, and IPs should also find out what are the common errors that are being committed earlier past, and for which are the instances that have brought down the image of IPs. If they could be documented, that could be a guiding reference. This is my
Thank you,
view.
sir. Thank you very much for that. We need to plead to the IBBI firstly कि जो उन्होंने 1 करोड़ रुपया मिनिमम पेड अप कैपिटल रखी हुई है एक एंटिटी बनाने की, और जो 25,000 रुपया एनुअल बेसिस पे वो चार्जेस लेते हैं, प्लस और भी कुछ चार्जेस हैं. वी बिग पीपल कैन अफोर्ड इट, बट एक जो बंदा नया नया एग्जाम पास करके आता है, वो 5-7 लोग मिलकर इसको करना चाहें, if you look same thing, you know, in partnership from creation of this thing in our other parallel institute of Institute of Chartered Accountants of India, the CMA and other, nothing like that is there. तो ये एक बहुत बड़ा स्टम्बलिंग ब्लॉक होता है फॉर एनी न्यू पर्सन टू कम एंड जॉइन एंड क्रिएट एन एंटिटी.
Correct. I do agree with you.
They should dilute that situation also. Initially, they might have thought that we people be too big and able to have resources of 1 crore rupees. But you think of a person who has no work and who has to, a lot of entities in the market are available for sale and no buyer is there. In any case, sir, Madan sir, your expert comment, please.
थैंक यू मनोज जी. ना जो आपने अभी इशू छेड़ा आपने और अनिल जी ने विद रिस्पेक्ट टू मेंबरशिप ऑफ दिस एसोसिएशन, आप सबसे पहले ये देखिए दैट 4500 आईपीज अक्रॉस द कंट्री, उसमें से 2100-2200 के पास एएफए है. इसका मतलब बाकी जो 2300 लोग हैं, दे आर नॉट इंटरेस्टेड, दे आर नॉट फुली इन्वॉल्व इन दिस कोड. 2200 में से कितने मेंबर्स के पास असाइनमेंट्स हैं? यू गेव दैट फिगर ऑल्सो. आई डोंट नो वेदर दैट फिगर इज राइट और नॉट. Still, if you are expecting that we should have 500 members, I think आपकी expectation, I wish you have that number. How many associations are there in the entire country? Every state, every city, every NCLT, you have in one or the other bar or association. आज अपने प्रोग्राम में देख लीजिए, you are saying that in association with NCLT, KBA, Kolkata, KIPF, Kerala, GIPA, New Delhi. If you have a heavy alignment or association with all these associations, why don't you merge all these and have your wider membership base? Or like I give an example from PSD Chamber of Commerce and Industry, that outside Delhi, in all these states, they have small chambers. All those small chambers are member of the PSD Chamber. So PSD Chamber consider all those members of those regional chambers as its own members. तो अब वो मान के चलिए, क्योंकि अदरवाइज अगर इतना वाइड स्प्रेड से सब रहेगा तो इट्स नॉट पॉसिबल टू हैव 500 मेंबर. 500 में 25% एक्टिव मेंबर्स ऑफ द एंटायर कंट्री आर विद यू. देन यू हैव दिस अपना उनके संजीव जी की, पांडे जी की आईपी वाली एसोसिएशन. तो लाइक सो मेनी एसोसिएशन. डोंट वरी हाउ मेनी मेंबर्स आर विद यू. समटाइम्स स्मॉल इज ब्यूटीफुल.
Okay. ठीक है सर, थैंक यू वेरी मच.
डोंट वरी अबाउट दैट बिग नंबर. आप अपना अच्छा काम करते चले जाइए, कारवा चलता रहेगा, लोग जुड़ते चले जाएंगे.
बिल्कुल ठीक बात है.
जुड़ना है वो जुड़ते चले जाएंगे. डोंट बॉदर अबाउट दिस नंबर कि कितने लोग आ रहे हैं, कितने अटेंड कर रहे हैं. अगर 30 लोग भी कर रहे हैं और क्वालिटी है 30 लोगों की, नो प्रॉब्लम.
करेक्ट.
एग्री
एंड आई विश, बिकॉज मैं देखो और किसी के प्रोग्राम में आऊं, आपके प्रोग्राम में जरूर कोशिश करता हूं मैं आने की.
सर आपको खींच के लाते हैं, हमारा हक है आपके ऊपर. आपने मेरे को फिर आईपी का बनाया अगर आपने हमारे प्रोग्राम में नहीं आना था तो.
So I wish this association the best, and आप काम करते चले जाओ. जहां जहां सपोर्ट चाहिए, I'm with you all.
ओके सर, ओके.
प्रसाद साहब देखो, प्रसाद साहब जैसे स्टॉलवर्ड्स आपके साथ हैं.
सर उनको खींच के ले आए ना हम अपने साथ.
He never says no to you.
That's good.
Definitely. We are with you. Don't worry. We'll walk with you and run with you.
we are honored with your words and encouragement also. Me and Anilji shall definitely, sit on this and, move forward as suggested by you, sir. हमारे मेंटर आप कहते हैं ना LSA में कहते हैं पहले भी और बाद में भी, तो आप हमारे पहले और बाद वाले हो तो तो वी रिस्पेक्ट योर सेइंग एंड वी
और
शैल
मोर
ऑनर
ओवर
योर सेइंग
देखिए ना,
आल्सो.
आज की डेट में आपको ऑन एवरीडे बेसिस एटलीस्ट 2 to 3 इवेंट्स आर देयर, particularly when such changes are there, amendments are there, the proposed discussion papers are there.
Yeah.
On every day 2-3 प्रोग्राम्स हो रहे हैं. मेंबर्स की भी अपनी लिमिटेशंस है कि कौन सा अटेंड करें कौन सा नहीं करें. ये तो यू आर लकी है ना, तो यू गेट 40-50 मेंबर्स. आई टेल यू दिस नॉट ए स्मॉल नंबर. ऑन ए
नहीं,
वर्किंग
आज
डे,
सर काफी कम
ऑन ए
है, कल तो बहुत ज्यादा
वर्किंग डे
है.
दोपहर के टाइम में 40-50 लोगों को ज्वाइन करना, मिरेकुलस टास्क.
नहीं, कल तो हमारे बहुत ज्यादा मेंबर थे, अराउंड 50 मीटर्स. इन एनी केस,
बस ठीक
विद
है.
दिस नोट सर, और कुछ सर, एनीथिंग
और
एल्स?
सबसे ज्यादा हैट्स ऑफ तो अनिल जी के जज्बे को है. आई टेल यू, wherever he is, whether in the country or outside the country, he is always for these programs. Knowledge dissemination में उनका कोई मुकाबला ही नहीं है.
कोई इनका कोई मुकाबला नहीं.
लाइक वॉट एवर वी लर्न, लाइक लोग कहते हैं कि ये सब हमारे कंपटीटर्स हैं, मैं कि नहीं, ये सारे हमारे कंपटीटर
कोई भी नहीं है जी, कोई भी नहीं है.
कोई हमारा कंपटीटर नहीं है. हम तो सिर्फ ये कहते हैं कि इन केस वी से समथिंग विच इज लॉ, एंड जिसको हम लॉ को एक्सप्लेन कर सकते हैं अपने एक्सपीरियंस के साथ, दिस इज व्हाट इज कंसिडर्ड एज शेयरिंग विद द सोसाइटी, शेयरिंग विद द पीयर्स. So thank you very much, Madanti. I think Manoj ji,
सर
we can
सर
conclude
सर
this.
सर हम आज की डेट में ना इनकी हम बात कर रहे थे. आप मदान साहब थोड़ा सा लेट ज्वाइन करा, मैं बस एक लाइन डाल के करूँगा. ये हमारे जो आईपी प्रोफेशन के है ना, ये हमारे हैं क्या कहते हैं, हमजा अली मज़ारी, जो धुरंधर फिल्म आई है, या जसकीरत कह लो या अनिल गोयल जी कह लो. ही enjoys that status in our IP fraternity and we love to have that there. सर आप क्या कहते हैं, अलहारी बलहारी जो भी था, आप अगर हमारी आईपी की कोई अलहारी है तो आप उसके किंग हो सर. वी रिस्पेक्ट यू,
अरे
यू
सर,
नो, एज
लिहारी.
लिहारी लिहारी. तो आप सर आईपी अगर फ्रेटर्निटी या आईपी वर्क एक लिहारी का है तो यू आर हमजा अली मज़ारी एंड जसकीरत और वट एवर यू, अनिल गोल, वट एवर यू कॉल यू, हीरो का जो भी नाम है, दैट इज देयर. विद दिस नोट सर, थैंक यू वेरी मच. आई एम रियली थैंकफुल टू माई ऑल द participants who joined us, and I just name few: Mr. Sanjay Kumar, Mr. Mukesh Kumar. Mr. Mukesh Kumar is our regular joining, and Mr. Partha Kumar Sen also, Mr. GVK Rao also, and on me on behalf of our association, and Mr. Sanjay Kumar Jha also. Thank you very much, sir. With this note, we are ending our meeting. See you very soon. Let any other new members come out to be there. We'll be with you to enlighten each other and learn from each other. Thank you very much.
Thank you.
Thank you, everyone. Thank you. Thanks
Thank
a
you,
lot.
sir. Thank you.